This conference will now be recorded.
Sorry. That's okay. Now we're live, recorded. And what we provide in exchange for a membership service is access to employment law attorneys, HR professionals, resources, forms, samples, guidance, training, stuff like this. And we don't do it on an hourly rate, we do it as a membership. So kind of like a chamber of commerce, you join and have access to services, same type of idea, only you have access to the professional staff and all of our resources. In fact, Spears Plumbing is one of our members. So with that, sorry, that
we just don't use you enough.
Which is
we need to use them more.
And correct that, use us more. All right, so what we're going to cover today is harassment prevention in the workplace. And what's unique about this is, as Dave described, there's a lot of media and publicity and a lot of issues. This is a hot topic with both state and federal departments of labor. And just in the general, there's a lot of attention to it. So as we go through the content today, what I first want to cover is the standards, the expectations. Moving then into the latter part, well, why do you care and what do you do about it? And how do you, in your environments, put steps into place to address harassment or complaints that come up about harassment? And we'll go from there. If you have questions again, and you're online, text them in or type them in. And if you're here, just raise your hand and ask. Okay? So one of the key considerations, Dave, the clicker is not working for me. Why don't you just hit the, there we go. All right, so first critical distinction to understand is when we're talking about harassment, not everything is illegal. People use the word harassment and it means certain things. What we're going to focus on are the differences between what is illegal under state and federal law and everything else. Okay, so at your companies, I'm going to guess that you have some standards and expectations. You expect your employees to show up on time, come prepared, have their tools, dress appropriately in company uniform. Those are examples of behavior that, as the slide indicates, are inappropriate. An inappropriate standard is something that you establish. It applies to your company, it applies to your employees, and when that standard is not met, you set the consequence. You determine what happens. So what is illegal and what is inappropriate, there can be some overlap, and we'll talk about those distinctions. But we're going to focus on the differences of inappropriate and how that applies to you guys, but then again, the illegal, and we'll spend more time on the illegal piece. Now, inappropriate, as I mentioned, the law does not necessarily get involved. Harassment may be inappropriate. Harassment is illegal. Now, inappropriate, again, you guys control the standards and expectations. If you have an employee handbook, you set out those established patterns and expectations in the handbook. And when they're not complied with, you take the appropriate action. At some point, however, behavior crosses a line and we enter into what is called illegal. Now, whether you recognize that the behavior is illegal, whether you knew about it, whether you have it in your handbook, it doesn't matter. If it is illegal, it is because the law, state or federal, has stepped in and said this type of behavior, if it occurs, is against the law, and you as an employer are obligated to correct it, to fix it, address it. And there's a variety of ways that you do that. So illegal behavior is harassment, or harassment covers that type of area. The distinction is important simply because your obligations and what you have to do in response to the various types of behaviors depends on which side of the line you follow. All right. Whether you're comfortable admitting it or acknowledging or even discussing it, all of us have prejudices. They are emotions, they're feelings, they're attitudes that typically are negative about others, other characteristics or characteristics that other people have. Let me ask you a question. And this, I guess, is more for the people in this room because, well, if you're online, you can respond too. Is it illegal to have a prejudice?
No.
It's not. You can think, you can feel, you can believe however you want. And the law doesn't get in between that. This isn't a morality or a religious question. It is just a legality question. You can have a prejudice. You can have those emotions, those feelings, those attitudes. What you can't do
is express it.
is express it. You can't allow that prejudice to manifest itself as a behavior in the workplace. When we talk about behavior, we're looking at.
So you can't
Go ahead.
express it,
Decisions.
or you can't, you can't,
Express it in the context of acting on it. And what I mean by that is behavior. Could be things you say, ways you treat other people, things that you write in an email, for example. Behavior that flows from a prejudice and manifests itself in the workplace is what we call discrimination. Ralph, you look like you have a question.
Well, it's
deep
just-
in thought.
well, only because a comment compared to an action or asking them to do something because of the prejudice. I'm just trying to understand the distinction between a comment made and an action or something that where you're saying, oh, I'm not sure how.
I think I know where you're going. So let's start with, is there a distinction between things I say and things I do in the context of discrimination? Is there a difference? If I just say it versus acting on it, is there a difference? Is that to start?
Something like that.
Okay,
Yeah.
so to start with, no. Behavior that's based off of a prejudice, and we'll talk about, there's a little piece that's missing, and we'll get that on the next slide. But that behavior, whether it's the way I speak or the way I treat others, or what I may write down or send in an email, that is behavior. We don't distinguish how that behavior occurs. It's just the fact that there is behavior based on a prejudice that the law gets involved with.
Yeah, I just come up with an idea or a thought.
Okay?
So a prejudice being I don't like blacks,
Okay?
but I hire blacks.
Okay? So if you manifest that dislike for a particular protected status, an African American, a black person, a Hispanic person, doesn't matter, and you refuse to hire them, for example, or you treat them differently as an employee,
Right,
don't
or
give them the benefits
Manifesting the
exactly,
dislike.
exactly.
That I
That's-
can understand being the problem, but saying something like that, is that a problem?
Potentially, it could be.
Okay.
It could be.
Then
So
that's what I want to hear.
Freedom of speech is out the window.
It's
well-
no longer there.
freedom of speech. So
How does Trump get it? Well, because he's the president.
as a private
Get there
employer,
and you can get figured
freedom
out.
of speech really doesn't matter in the context of can your employees do or say these things. If you say something like that, what I would be looking for if I was representing an employee is you have a statement that says, I dislike a protected class. Now, if I see any kind of behavior that coincides or supports that statement, that's a torpedo to the side. You're going down. So statements like that, although perhaps taken alone would not be damning, when they are together with behavior, that becomes very, very solid evidence of a discriminatory behavior or practice. And let me give a little bit more on that point. So harassment is a type of discrimination. Now again, the word harassment means a variety of different things. For today's discussion, it's purely illegal content based on a prejudice that occurs in the workplace. So harassment is a type of discrimination, but here's the kicker, and Ralph, this is where I wanted to go with your comment. Harassment must be based on a protected characteristic. A protected characteristic is, for example, this list right here. We'll talk about some of these. So you have here on this slide a list of a variety of different characteristics. Not all of these are protected. Most of them are. Now, a protected class, and this is important, a protected characteristic is one that is defined by law, whether it's a state law or a federal law, but the law says this behavior or behavior because of this particular characteristic in the workplace is illegal. It cannot occur. So, for example, let me just ask one particular question. What do you think about country music fans? Do you think country music fans is a protected status defined by law?
You would think they would.
You think
Well,
so?
that
You
usually
think
has
not?
something to do with their socioeconomic status too. So,
Had to have come from the
I mean,
south.
right.
They fall in disability.
They're disabled,
Yeah.
they're disability.
Yeah.
That's new. All right.
So it could be.
We have to be careful.
Right.
Well, let's go to that one step further. So, again, as I mentioned, not every characteristic is protected. You have state laws and you have federal laws that create protected characteristics. There must be a statute that defines that. These are the protected characteristics under federal law. So Ralph, if you wanted a picture, this is the one you want to get. These are the characteristics defined by federal law that are off limits in the workplace. So behavior, language, gestures, treatment, whether it's coworker to coworker or a company to employee. And to use Ralph's example, an employer says, I don't like black people. Okay, well, that's a prejudice, and that in and of itself is not illegal. But if I then choose to treat a black person who's my employee differently from I treat a Caucasian person, or if I choose not to hire a black person and only hire Caucasian individuals, that would be discrimination. So behavior that flows from that prejudice and spills over into the workplace. So let me cover quickly the different protected characteristics, and then we'll talk about the protected classes that are defined here in the state of Utah. Now, first question when we look at a protected characteristic is this: how many employees do you have? If you have over 15 employees, these protected characteristics apply. If you have over 20, the age protected characteristic also applies. So keep that in mind. There is a jurisdictional threshold. You need 15 employees or more, or for age, 20 employees or more. And that's 20 employees on your payroll, whether they're full-time, part-time, temporary, as needed, does not matter.
So you can't ask how old they are, but you can ask what their date of birth is.
That would be a question that does relate to age. So depending on why you're asking for age or the date of birth,
That on all of our.
that's a potential problem also. So questions, and let's start with age. There's good comments on this. So on an application or in a interview, you're the employer asking the interview questions, and you ask the individual, tell me what year you graduated from high school. Now the question then becomes, well, what if I tell you, and I'm 43, I graduated in 1993, so I tell you, I graduated in 93.
That doesn't mean you can tell their age by that, though.
Well, actually the math would give some indication that you're
Kind of, within a year or two.
Unless you're Sheldon.
Sheldon.
Oh, come on. You haven't watched Big
the
Bang?
Big Bang Theory.
Oh.
So
I
to
don't
your
watch
point,
Wait till he was 6.
I don't know.
to your point though, it's more likely that that question is going to lead you to conclude that I am indeed protected by age. And frankly, in Utah law, a state statute prohibits you from asking my date of birth, my social security number, or some other identifying information pre-offer of employment too. So some restrictions there.
If we have it on an application, could we get in trouble?
You can. You shouldn't have it on an application. So date of birth, driver's
But
license.
once they're hired, you've got to have a copy of their driver's
Correct.
license.
I know you have everything.
So,
I mean,
yeah.
you get them a
But
credit
it's
card, you have to have.
pre-hire.
Pre-hire,
So
correct.
this is literally saying, once you're over 40, you are old.
Oh, this is pre-hire
That's the
question.
statute. And
That's
that's
the
what's
statute.
interesting is 1967, this law was passed to protect older workers. Now, we don't think of 40 necessarily as an older worker today, but that is nonetheless still the status. That's the protection. So I, as an older worker in the workplace, can't be treated differently or to my detriment because I'm over the age of 40. All right. Race, religion, national origin, sex, and color. Those were passed in 1964 under Title VII, federal law in response to the Civil Rights Movement. Race refers to ethnicity, African American, Hispanic, Caucasian, Pacific Islander, Native American. Those are all examples of race. All of those characteristics are
What if they
protected.
hand you a resume, and on that resume, it's got graduation from high school, that day,
You didn't ask it, so it's
and
probably okay.
you keep that resume, are you still breaking the law?
Great question. So on a resume, an applicant discloses a protected characteristic, whether it's age, disability, race, religion, something like that. Is that illegal? No. But the question becomes, what do you do with the information? So it's up to you as an employer to show we don't take that information into consideration when we're making a hiring decision.
Well, how do they know? I mean, they can still come and say, well, you didn't hire me because I was 43.
Sure, they can do that. You're absolutely right. So that's where
But they
your
have to prove it.
policy, your process, your procedures need to show that you
Everybody
don't
can hear your
factor in that type of protected characteristic into your decision-making process.
Well, to make sure you hire a 43-year-old or 40-year-old and then you're done.
Yeah.
Well, I would disagree with that. It's
Oh,
not that
crap.
simple.
What if he's 43 and you go through the resume, and in the resume, there's things that you don't like, so you don't hire him because of other things, and he can come back and say, well, you didn't hire me because I was 40 over 40.
Excellent point. So every employee that you have can make a claim. There's nothing that any attorney can do, or you as an employer, to stop that. But my point is this, and this is what we're going to focus on at the latter half of this. How do you defend yourself? So you, again, have the obligation and the opportunity, I would say, to demonstrate that any protected characteristic did not factor into your decision. So you do that by saying, in your resume, we'll use your example. I've seen the resume, yeah, it discloses his age, so what? Here's his skills, here's his ability, here's his training. When I compare this individual with the other pool of applicants, based on these essential functions, he is not the most qualified because A, B, C, and D, whatever those reasons are. Now, if that's all in your head, that's okay, but your ability to persuade that you didn't use age as a factor is a little weaker, and your defensive position is weaker if you can't provide a persuasive argument that says you didn't factor in age, like on paper or your interview process. What are you looking for? Here's the posting, here's the qualifications. This person is not the most qualified, and we selected this other person because that person is more qualified based on these characteristics. So document, paper the file. Show that you have some paperwork to support your decision. And you can make those decisions, and if you do get a claim, you get a claim. But you can defend it if you have the persuasive support to show that age or other protected classes didn't factor into your decision. That's the distinction. Okay? Oh, go ahead.
So I don't know how many of you guys are involved in the RAPIDS program, HUD, and use the federal government to put your apprentice in the program, right?
Okay.
So they're the guy that administers it, come and sit down with us, and he's telling us we actually have to record all these protected classes of what kind of person came in and that. So how do you do that through the interview process and not get yourself in trouble? Because you're taking he used females as the example when he was talking to us. He says after a certain point, if you don't have the ratio, then you're going to have to go out and specifically look to hire in these fields to attract females.
Okay. What you're describing is in simple terms, affirmative action. I'm not going to cover that today, but if you do have federal contracts, the federal government can mandate that you diversify your workforce based off of protected characteristics that are underrepresented in your company. So your obligation, and there's a lot more detail to this than the 30 seconds I'm going to say, but your obligation in effect, based on your demographics, is to diversify your workforce or to attempt to diversify and show that you've made those attempts based on what underserved protected classes are in your workforce. And then document that. Now, again, 30 seconds, that's like an affirmative action 101, that's an 8-hour class. So there's a whole lot more to it, and we'll get sideways if we keep going with it. So I'm going to pause on that one. Just know that there's a whole set of specific ways in which you do that and requirements per the federal government mandate as you contract with them or receive money from them. And they can do that because it's contractual relationship and they can tell you what the terms are.
But they will acknowledge effort, documented effort.
Yes, yeah, you have to
So it's
show
not like you have
effort.
to do it.
Correct.
You show what you're trying to do, advertise for more, those type of things.
Well, with you're saying you can't record any of that. You can't have that on an application.
Affirmative action is different.
How do you?
The federal law and it's going to be aware of that. It's a little different. If you're on the call, go ahead and mute your phone so that we don't get the feedback, please. That'll help. All right. Race, I barely got through that one. Religion, any sincerely held religious belief. That means more than just I attend a particular church or a denomination on Sunday. It's any sincerely held religious belief. It's extremely broad. National origin, the country where you come from, where you were born, or your heritage ancestors. My last name is Nelson. That's a Danish name. I am a 6th generation Danish descendant on my father's side. My last name is a characteristic of my national origin. Sex, that refers to gender, male or female. Now, federal law only describes male and female as protected characteristics. There's a division of opinion in federal law right now based on the federal court system. But under Utah law, we'll see in the next slide that that doesn't matter. We'll talk about that in a minute. The last one, color, that literally refers to the color of your skin. All shades, all pigments are protected in the workplace, again, as employees. Those are the Title VII protected characteristics. We talked about age. Last couple, disability. 1990, the Americans with Disabilities Act was passed, protecting individuals who have a disability from discrimination in the workforce. So same characteristic. It's the same as if the color of skin or my gender. Disability is protected, as is military duty. If you've served in the military, active or federal, state or reserve, doesn't matter. That choice, at least today, is a protected characteristic, meaning you can't be treated differently because of military service. And there's some other protections that are fairly broad too. Go ahead, Ralph, you have a question?
In those handicaps scenarios, though, or disabilities, I mean, we definitely, in most cases, in hiring for a plumber, would be very tough to have somebody in a wheelchair.
You're right. So the way that the law defines an issue like that, it is to say that you, the employer, you describe what the essential functions are.
Okay.
Mobility, bending, kneeling, squatting, pushing, crawling, whatever that is. Okay. You define what those are.
Yep.
Applicants come to you and you take them as they are. So a person in a wheelchair, can a person in a wheelchair get down on his or her hands and knees and crawl under a crawl space and do some plumbing repairs? Maybe, maybe not, I don't know. But the question in the interview process that you can ask is, here are the essential functions. Can you perform these, yes or no, with or without an accommodation? And if the applicant says no, they've told you they're not qualified for the job. The fact that they're disabled doesn't matter now. They've disqualified themselves from the position. But if they say yes, and you see that they're in a wheelchair and you know what you know about how your job sites are, you can ask the question, well, for example, are these functions are performed in a variety of different job sites? Some of them do not have access to a wheelchair. You can't get a wheelchair on the job, or they require that you're on your hands and knees crawling through duct space. Can you describe for me how you will perform the essential functions under those conditions?
So they can't force you to build ramps on the job site?
Not necessarily.
That's what I was.
Especially, you don't have control necessarily over the job sites.
Yeah.
So
Elevator.
there's ways in which
So
you can
you can get
structure
up and
your
back
interview
in.
process, the way in which you interact with candidates to address these types of situations so that you're better protected should a claim come up. Because to your point, anybody can make a claim.
What about mental disability?
Same thing, doesn't matter if it's physical or mental. So anxiety, depression, PTSD, those are all disabilities under the ADA. They're just mental rather than physical.
How do you handle that?
That's an 8-hour discussion.
Okay.
And I'd be happy to tell you more, but just not right now. We don't have the time for that. That is a very, the ADA is probably, in my opinion, one of the most challenging aspects of being an employer. There's a lot of challenges and nuances with that.
So on, just real quick, if you can, if we had hired somebody and then found out that they have some of those issues,
you take them at that point, you've hired them, they're an employee,
Yep.
and they're entitled to the protections of the ADA, which requires what we call an interactive discussion. And that interactive discussion and process leads to an accommodation, whatever that is, that enables them to do the job, this essential functions. That's your obligation in managing the ADA with a disabled employee.
Like your building, you have stairs up to your office.
Yeah.
If it was an older building and you didn't have your elevator yet.
I know.
That's a little different, but kind of the same standard. It's just slightly different, but yeah, the process would be similar.
Okay, so here's a little, I don't want to throw you off.
Go ahead, no, go
Let's
ahead.
just say you hire a person to do plumbing service work. 6 months later, they start to tell you, I have anxiety when I deal with the customer. I can't do that, blah, blah, blah. you have to try to accommodate their situation.
Yes. Now, an accommodation, and let me be clear on this. An accommodation does not mean, okay, you don't have to talk to customers now. We'll accommodate you. That's not what an accommodation means. The law requires that as an accommodation, you're giving something or doing something that enables them to do the job, to perform the essential function. So a face-to-face customer interaction is indeed an essential function. And the employee says, I have anxiety, it makes me nervous, I clam up, I can't talk, I can't think. Your job under the ADA would be to figure out some way to enable that person to perform those functions. And there's a variety of different ways in
Or
which
can
that
you
can
just
happen.
solve it by having a RIF in your company, a reduction in force?
So the question was, can we just RIF that person? Sure, you can RIF them, and if you get a plaintiff's attorney who finds out that you RIF the disabled person because he told you that he was disabled and couldn't do the
That
job,
wouldn't be the reason.
and you, well,
Reduction in
yeah.
force is reduction in force.
yeah, but reduction in force is a label. Your job and your obligation is to
As long as
justify
they
the
could-
reasons below it.
As long as they can prove that you hired somebody to replace them.
So, this is great. I love this.
I know this gets sticky, but I mean,
No.
that was just literally, I mean,
It's
that's
a
one of
way
those.
out, I think.
Actually, if I was a plaintiff's attorney, you'd be dead in the water. Because if I make the claim and I have a fact, the facts are what we've just described. Disabled employee tells you disability, can't do the job, and you then label that guy as a RIF and suddenly he's gone. And your justification is that's a reduction in force. Even if you don't hire anybody else, doesn't matter. The connection between the knowledge and the claim of the ADA assistance and the outcome, that's going to be a tough one to beat. And that one, it's going to cost you some money on the check. So yeah, don't do that.
The accommodation, isn't it worded, it has to be a reasonable?
Reasonable, yeah, like,
Correct.
I can't send another employee to stand there and hold their hand and
Correct.
do the talk, it's impossible. So,
Reasonable, again, in a simple term, how can I provide something, whatever that is, that will enable performance, that doesn't create a direct threat of safety or an undue hardship?
You could
for the
probably go to the
organization.
government and get them to subsidize his wage, actually.
So
Somewhere, there's gonna be some funds.
you didn't bring that up. I mean, you've got guys that, I mean, that we see that don't perform properly on the job, or don't clean up, or don't do something on the job. You're saying I can't let them go for those reasons?
No, that's not what I'm saying. What I'm saying is if I've come to you as your employee who doesn't do the cleanup,
Yeah.
and you're telling me, hey, Ryan, you need to do the cleanup, and I tell you, hey, I've got a condition, mental, physical, whatever that is,
I don't like it.
that
I have a
prevents me
condition
from
of
doing
it.
that,
But if he's never said anything to you,
that's
Yeah.
different.
okay.
Okay.
Because
That's
I've got a
different.
bunch of guys that never said, they're not gonna come to me and tell me, but I go, this guy is not working out.
So
This guy is not where I need him to be.
knowledge of a condition is what brings the ADA into play.
Okay,
Or if the condition is open or obvious,
okay.
like I'm missing an arm or I'm in a
I
wheelchair.
think this is proving to me that we need to have more HR training.
Well,
Negotiation.
this is what we do. I mean, this is,
Exactly. So,
just from your
Being
questions
that.
alone, this is
Oh,
complex
it is-
stuff.
It's getting worse.
It is. All right, moving.
This is becoming a very big issue in our companies, and especially if you get bigger, it gets even worse.
You become a bigger target and more complex, and it's easier to make claims because there's more moving pieces. This is why we exist as an organization.
Well,
Dave, will you advance the slide for me, please? My clicker stopped working.
And so does his. Screen burn.
I'll tell you one with comfort systems with me that I had happen.
All right, these are the state of Utah protected characteristics. Now, if you'll notice, sexual orientation and gender identity are on this list as protections within the state of Utah.
That's what you got.
2015,
Gender identity.
Utah amended its discrimination statute to include sexual orientation, so whether I'm heterosexual, homosexual, or somewhere in between, and gender identity, whether I am an anatomical male but identify as a female and hold myself out as a female in the workforce, those characteristics are protected. And here's the kicker. If coworkers disagree with that, that's fine, they can disagree, but they can't treat those individuals differently in the workforce because they're practed characteristics, the same as the color of skin.
So
Same
who's
as
on the
my
hook
age.
for that? The employer or the
You, the
employee?
employer,
If
Now,
the employee
employer-
acts out,
but it's your job environment, it's your company. You're liable as an employer for doing business in the US to maintain a harassment and discrimination free.
Well, let's say it's a first offense. Let's say you've never had any trouble
Okay.
and employees are on a job site.
Yeah.
One of them calls someone else something. You have no opportunity to solve that.
I have slides that will address that.
Okay.
We'll talk about that exact process, okay? So the last part, though, of Utah law is this other expressive piece. So Utah created a compromise, if you will, recognizing that sexual orientation and gender identity are important characteristics to be protected, but at the same time, so is religious expression. So is the freedom of speech under the federal and state constitutions. So Utah created an expressive protection for expressive activity in the workplace also. Easy, simple example. I can say to a coworker, I believe that marriage should be between a man and a woman. Coworker can say to me, well, I believe that marriage should be between whoever that wants to be married. That is a protected conversation for both of us within the workplace. We're expressing religious or moral beliefs, and the law protects that. Now, what I can't do is harass or be harassed because of that expressive moral belief. All right. So in the work environment, any one of these individuals can create a hostile work environment. You can have a supervisor to supervisor, supervisor to employee. You can even have a non-employee create a hostile work environment by how they treat your employees. Now, granted, you need to be aware of that behavior, but if you have a general contractor who doesn't like Hispanic people, and you happen to employ a Hispanic person, and that general contractor on your site degrades or belittles or demeans that Hispanic individual because of his race or the color of his skin, and you become aware of it, your obligation is to eliminate that aspect of harassment from the workplace.
What about an owner?
Doesn't matter. It's someone with access to the property in an environment that you have some control over. It's tough. It's tough. And I'm not going to shy away from that. Those are difficult conversations, but nonetheless, you are, if you will, obligated to protect your employee from discrimination by your employees, but also non-employees who are invitees onto the property where you're working, into your job sites. Now, I'm not going to spend a lot of time on this test. I just want you to understand that when we look at harassment, harassment is a recipe, if you will, that requires 4 parts. Conduct based on a protected status, which we've talked about. Conduct that is unwelcome, meaning I, the individual, I don't like that you treat me differently because of my age or tease me because of my age or the color of my skin. That behavior is unreasonably offensive. And finally, the behavior is severe, meaning it's really bad and maybe it only happens once, or it's pervasive. It happens all the time, but you know, it's not that bad. It's frequency that makes it bad. So when we look at illegal behavior in the workplace, this is the recipe or the test, if you will, under which we analyze behavior. Now, for today's discussion, just be aware that that's what it is. We don't need to go any deeper than that, but that's the legal standard, okay? Your job as an employer is right up here, the conduct based on a protected status and then the unwelcome piece. And this touches on your question. I don't know, remind me of your name, your husband there?
Jason.
Jason, this is your question. So we have conduct based on a protected status. I have an employee who's been degraded, belittled, intimidated, whatever it is, because of age or race or whatever. That employee comes to you and says, hey, this is what happened. I'm not okay with that. At that point, behavior has been demonstrated to be unwelcome. It's based on a protected status. You now have to fix that and address it. And how you do that, we'll talk about it. But you're now on notice that it's happened. Now, if the employee never complains and you don't ever find out about it, do you have an obligation? Not really. But if you observe it, or if a bystander observes it, or if a manager observes it, technically the company at that point, if a manager observes it, is on notice. And that manager has an obligation to bring it up so that the company can address it. All right. So retaliation, I bring it up just so that you understand, retaliation is the second most frequently claimed form of discrimination from under federal law. And retaliation, if you have kids, you already intuitively understand how this works. I have a few kids, and I have two that don't get along very well, and I have these kind of interactions. Somebody says something or does something, there's a punch or a blow thrown, and then there's another blow thrown. That's retaliation. Now put that in the context of the employment relationship, and here's what happens. I, as a protected individual under state or federal law, I have a right to complain about harassment in the workplace. I can say, I believe that I've been treated differently because of my age, my skin color, whatever that is. If I complain, and after the complaint am treated differently in an adverse way because of that complaint, that's retaliation. So your job when an individual does bring to your attention that there's a complaint of harassment, whether the complaint is right or wrong doesn't matter. It's the right to complain that's protected, and that individual we have to make sure is not now retaliated against because they've made a claim or participated in an investigation or given an interview as a witness of harassment. They can't be treated differently because of that participation. So retaliation is designed to protect the right to bring up these types of issues in the workplace or participate in that process without being retaliated against for doing so. Okay, so here's where we get to the meat of the bone. What are your responsibilities? Now, as an employer doing business in the US and in the state of Utah, this is your obligation. Prevent, correct, and when you do correct, do so in a prompt and appropriate way. Prevention. What is prevention? There's a variety of things that fall under prevention. First, it's having a policy. If you don't have an employee handbook, it's generally recommended and best practice. But if you don't, you still should have some type of policy that defines what is your equal employment opportunity standards, what are the protected characteristics that are off limits in the workforce that applies to you, state and federal, but also a complaint mechanism. How do you handle that? And does the complaint mechanism actually work? It also involves training. Something like this, although if you were all employees and I was doing this at your company, this would look a little different, but training for your employees is an expectation. In Utah, it's not required, but it is a very good way to show that you've educated your workforce about what the issues are and how to deal with them if they come up. And that's part of, in your question, how you defend yourself. You show that you are a good employer because you've done these things. And then the last part of prevention is just deterrence. All of your managers and supervisors should understand what this is. They should be empowered and obligated to address it in the workforce if they see it, because they are acting on your behalf. They are the employer. When you do have a claim, though, employee comes to you and says, hey, so-and-so's getting after me because I have whatever protected characteristic that is, and I don't like it. Make it stop. You now spring into action. And that's where we go to the investigation phase. An investigation is where you're asking questions to determine what's happened. Who you ask those questions depends on who's involved, depends on who's made the claim, depends on what the facts are. But you have to investigate all of the claims that come to your attention. Some you may need to do by an outside party. Some you can probably do internally and have someone, an employee, conduct that investigation. The key with an investigation, though, is in order to show that you take this stuff seriously, you have to react and do so timely and thoroughly, making sure that from an outside perspective, you've been fair, you've treated the parties appropriately, and come to a fair conclusion, whatever that may be. If you do impose corrective action, the next step, corrective action, in a trite way of saying it, the punishment needs to fit the behavior. Whatever it is that you impose as a consequence, make sure that it is commensurate with the behavior. So if and I'll use just me as an example, I have a female secretary. If I come into the office one day, whisper something sexually inappropriate, and smack her on the rear end, that's pretty bad. So the consequence for that behavior should be pretty bad, okay? And that would require an investigation. She would be interviewed, I would be interviewed, bystanders, if there were any, would be interviewed. And you now, as an employer, are trying to conclude, well, what happened? Who do I believe more? And then you take action and impose a consequence. The last part that, again, and I can't emphasize this enough, Once you've gone through this process, have a complaint investigated, taken action to address the behavior, you must ensure that you prohibit retaliation. Retaliation is so easy to claim, and frankly, it's so easy to prove. All I have to do is show that I made a complaint, and that after I made the complaint, I was treated differently in a negative or an adverse way, such as my job's changed, I lost my job functioned, my pay rate was reduced, I was put on some kind of furlough. Those are all negative actions towards me, and if you've done that, or if I can show that you've done that because of my complaint, that's retaliation. There's a connection between the two, and that's all it takes to prove that claim. So buyer beware with those. It's important that as an employer you understand that and emphasize making sure that it doesn't happen in your workforce. All right, a couple other points. When you look at your harassment policy, in your handbook, there are some standard provisions that you should include. These are the highlights. First, and we have a sample paragraph or a sample policy that we share with our member companies that addresses all of these pieces. It's compliant with Utah law. We update it as cases or the law changes. But in this policy, you're describing first that we are an equal opportunity employer, and we prohibit harassment in the workplace based on those protected characteristics that we discussed. Second, because under the ADA and Utah law, you have an obligation to accommodate under certain circumstances like a disability or pregnancy, we include a statement that says, if you need an accommodation, here's how you request it, and here's what we do. Next, you should have a provision specifically addressing sexual harassment. Now, sexual harassment is harassment. The only difference is instead of looking at the protected class, such as the color of my skin, my age, my gender, we're focusing on the conduct. Is the conduct sexual in nature? And if the conduct is sexual in nature, and it is unwelcome, unreasonably offensive, and severe or pervasive, you have a sexual harassment claim. And the outcome and the liability is generally the same. The only difference is, again, we're looking at the conduct. Is it sexual in nature? We don't care about the individuals involved in their gender. Could be men harassing each other and talking about sexually explicit stuff. That could be sexual harassment. Could be men and women. Could be just women. We don't look and focus on the gender. We focus on the conduct.
So go back to the accommodations. We just had a secretary. She worked for us for about 3 years. Then she had a baby. And we gave her 6 weeks, I think is what you're supposed to give them, right? Opportunity to come back after 6 weeks.
Utah doesn't specify a duration of time. It
We
just
thought
says
there was. We used 6 weeks. We got that from somewhere. We probably should have called you.
you should.
But
That's what you pay for.
yeah, exactly. I know. But it wasn't a problem. But anyway, when she came back, she just wanted to work part-time.
Okay.
And we told her, no, you need to fill your full-time position.
Okay.
And so we let her go.
So in that instance, and I'm going to make an assumption here that she only wanted to work part-time because there was something related to the pregnancy, whether it was breastfeeding, whether it was postpartum depression,
She just
something.
wanted to be a mom. Yeah.
Perhaps. Now, conditions related to pregnancy under Utah law are a protected characteristic, and the law does require an accommodation by the employer for those types of conditions arising from pregnancy, breastfeeding, or other pregnancy-related conditions. To your point, you required that she come back and work her full-time job because that was the position.
7 to 4 o'clock.
Now, an accommodation is not creating something new or different from what the position was and is.
Right.
So in that instance, I would say that's not a reasonable accommodation and is different from what the law would require
I
there.
mean, she had no problem because she just wanted to go part-time. I mean, she wanted to work part-time. But
Sure.
We didn't
Sure.
need her part-time. We needed her full-time.
Okay. Now, another example where an accommodation would be required with a pregnant employee, or let's say, delivered the baby, come back to work, is breastfeeding. She needs breaks to express milk because she's pumping.
Yeah.
That time away from the job would be an accommodation that the Utah law would
We even
require
let her
that you
bring a
provide.
baby. I mean, she had her fasting out by her desk.
Well, you don't have to allow that under Utah law. You don't have to allow them to
But
do
we
We
it.
have that with a dog.
But we loved her as a secretary. We wanted to accommodate her and use her, but she just couldn't do full-time.
Sure.
So.
All right, so going back to the provisions, sexual harassment should be as an important part of your policy. needs to be in there. The complaint procedure. Now, the complaint procedure, you need to make sure with your complaint procedure that you actually have a process with people identified where an employee can come to that individual and say, I believe that I've been harassed or sexually harassed or retaliated against, and disclose it to the company. So there's some training for those individuals who are authorized to receive those complaints. You can't just, go and do, your name's on the list. There's some training that you would need to provide for them to make sure that they do it correctly.
I don't think I want you coming and telling my employees what they can.
And their rights. And their rights.
And their rights to come after.
So that's your choice.
I don't,
But
it scares me.
It should.
It does.
It
because,
should.
I mean, even telling them about it, telling them that they got to report an incident on an accident.
Yeah.
All of a sudden, I started getting all kinds of stuff.
So here's from the perspective of the law and an agency that enforces the law, like the Equal Employment Opportunity Commission or the Utah Anti-Discrimination and Labor Division here in the state. From their perspective, those protections are in place to preserve and protect the individual employees because they shouldn't have to come to work in an environment that's unsafe or where there's harassment.
Right.
And as an employer, our obligation is then to figure out what you described, which is, okay, if I train them on this, I'm going to get complaints. Well, put stuff in place to address with that because that's how the law is supposed to work. That's how the process is supposed to work. Now, it is an inconvenience, and I won't disagree with that. It is a headache because now you've got people telling you that things are wrong. But welcome to doing business in the U.S.
Yeah.
That's what's required. Now, a good defensive employer will put measures in place to ensure that should a claim come up, they can defend themselves. The analogy I like to use is it's a chess match.
Yeah.
The other party has their pieces and they put them where they put them. You have your pieces and you put them where you put them. The goal is to put your pieces in a position such that you can defend what happens and you can be successful in that defense. Now, there's a variety of ways that we do that, but that's what we do. That's why we exist as an
I just
organization.
know that there's employees, not just employees, there's just people at times that don't want to come to work.
They complain.
That don't want to be around or don't want to work or whatever it is, and they're finding some way not to.
Sure, and complaint is one of those ways.
And get compensated for doing that.
And to complain and get compensated for it is exactly what we're talking about.
So this is a great example.
So do you try to tell them all the things that they could do, or do you let it just happen and then defend that and then put those, or make sure that you try to have them in place? That's what I'm
Keep
trying
your
to.
defenses in place and not educate them on what they could do.
Well,
I don't know. That's what I'm trying to figure out.
great
Which way are you
question.
trying?
So in before the session started tonight, you guys were talking about something with licensing
Yes.
and things like that. And it was a very interesting discussion. And your point to this gentleman was, well, think that through a little more. Think about this. Think about that. This type of a situation is exactly the same approach.
Exactly.
You've got to look beyond the edge of the hood. You've got to look miles down the road and put pieces in place today so that if you have the frequent habitual complainer who is looking for a quick buck and an opportunity to drag you in as a company into a claim process, you have to have things in place today with that possibility in mind. And part of it, to your point, is a policy. It's prevention. It's training. It is giving your employees an understanding of what this is because that's part of your defense. You show that you have acted reasonably as an employer and you have provided the training. They know what it is. And if they don't complain, that's good for us. They knew about it.
Good defense is good offense.
Yeah. Well, I mean, we have good policies, but I'm just saying a national, now I've got to give this of what happened.
No, well,
You don't want to do
no, let's, because I've
Okay.
got 2 minutes.
All right, I'll just
We
talk
can-
to you.
we can-
I'll
we
tell
can-
you.
I got it here.
Just short
why.
though,
It is.
Story,
your employees know about all
Oh, yeah.
Well,
this.
that's
You're not hiding anything.
especially the millennials.
They're better informed in this than any of us.
to that point. Federal and state agencies go to great lengths, and our tax dollars support this, public education. There is an app from the Federal Department of Labor, tells me everything I need to know, tells me all of this. And you have posters on all of your jobs or your offices. All of that poster tells me everything we've covered today. Now, do they read it? It's like not, but it's online, it's in the media, it's on websites, it's on my phone, it's an app, I can get it anywhere. Again, for us as a defensive strategic decision, telling them what it is, fine. It's what we should do. Knowing then that we have the other mechanisms in place to successfully defend if a claim comes up.
But that goes back to the fact, if you have a good team, and including employers' council as part of your team, really helps process, because they got now several problems. We had good policies in place, but they helped us take the next step when they started getting before the state.
You wouldn't hire a framer. You were teasing about framers earlier. You wouldn't hire a framer necessarily to be a licensed plumber. This is what we do. This is all we do. It's the same analogy as the plumber. You hire a plumber to do a plumbing job. You hire an HR person, or you bring on an HR consultant or a team to assist with that type of work. And this is why we exist. This is what we do. So last couple things. When you do have complaints, and this is tough, you may have the habitual frequent flyer who complains about every little thing. Under most circumstances, you still need to take those complaints seriously and give it at least a fair look and investigation. When a manager receives a complaint, make sure that they escalate the issue to HR, whoever that is within your organizations. Monitor the workforce or the workplace for retaliation. And again, if retaliation occurs or harassment or discrimination, make sure that you take appropriate action, do something about it. All right, this is my contact information. Got my email there. If you want to know more about what we do, it's not a sales pitch, it's just an offer. I'd be happy to have that conversation with you. Also, the last line is my social media platform. Push a lot of content through LinkedIn, Facebook, Twitter, and also a blog post. You can subscribe to it. Content's there, and I think it's pretty good stuff. All right, questions?
Any questions out there?
Okay, if you have questions, you just need to unmute
Dennis,
your
are you
mic.
awake down there?
Oh,
This way.
Scooney made it. Is it Scooney?
Okay.
All right, well, silence is, I guess, no questions. So thank you for coming today and participating. Appreciate the opportunity to talk
Ryan,
about it.
thank you very much.
You're welcome.
It was very,
Thank you.
it shows my previous life, I was HR, and just goes to show that I need to pay more attention to some of those things and get more training. So appreciate you very much for that.
Thanks for having me.
So with that being said, that's all that we have.